Yeah, this is Paul. Yeah. I was looking in this law dictionary what's called good behavior, lawful conduct. The phrase is often used in reference to the orderly conduct of a prisoner, and such good behavior is essential for parole or for something, for shortening a sentence in jail. Yeah. And then there's what's called give notice, to inform somebody that a legal suit is about to take place. Such notice usually served legally, although it may be informal notification. Yes. But I got to thinking about that good behavior. I had read in the Constitution, Article number 3, the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as a Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. It seems that Article 3 of the judicial branch says that judges, they don't call them justices, they call them judges, both of the Supreme and inferior courts shall hold their offices during good behavior. And this gives the example of prisoners, but it seems that lawful conduct is a necessary condition of employment for any Supreme Court judge. Now, in looking at Article number 3, the judicial power shall extend in all cases in law and equity arising under this constitutional law, United States treaties made, so on and so forth. They have here clause 2, in all cases affecting ambassadors, other public ministers, consuls, and those in which a state shall be party. The Supreme Court shall have original jurisdiction. Now, as I understand, that's original power. Now, my understanding of the Supreme Court was that first you go through a district court, and then when you don't like the answer of the district court, you go through the superior court, and when you don't like that answer, you go through the regional appellate court, and when you don't like that answer, then you go through the Supreme Court of the state. And when you don't like that answer, you go through the Supreme Court of the United States. But it seems there is a place of original jurisdiction, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions under such regulations as Congress shall make. So they have appellate jurisdictions in all of these other situations, but they have original jurisdiction when it involves the state being a party. Now, I would interpret that as meaning any state of the United States that gets sued for violating their own Constitution and the United States Constitution, and then violates the speedy trial as an amendment of the Constitution, really violated the good behavior of being judges. Now, it could be that the original jurisdiction of all of these lawsuits could be Supreme Court jurisdiction, and I don't know what Ginsburg is doing right now. Or Lena Kagan, or the new guy from Colorado, or Sotomayor, but I had told them in the past, I said, I'm going to fire every one of you! Every Supreme Court Justice of the United States Court! Now, I have this feeling that John Roberts, Supreme Court Justice of the United States Supreme Court, in allowing for the state of Washington to obstruct my rights, and then allowing for Squim to no longer be the plaintiff, and allowing for the state of Washington to be the plaintiff, I'm thinking that I'm going to be having jury trials, and the United States Supreme Court of the judicial branch of the United States federal government is going to get to hear a jury trial. Now, as I read it, and I could be wrong, there is a place for original jurisdiction where the Supreme Court, it says here in the judicial, let me just read this one. inferior during good times and shall not diminish, and so on and so forth, so on effect. The trial of all crimes of application shall be by jury, and such trial shall be held in a state where the said crimes have been committed. But in cases affecting vastness and those in which a state shall be a party. Now let's say it's Paul C. Budnick as a citizen of the United States, suing Washington State, and the Supreme Court of the United States Court gets to hear the jury trial. Now it's probably been a while since the Supreme Court has actually been the jurisdiction, the original power of the lawsuit. But it could be that instead of just appellate decisions of reviewing what other minor courts have done, it might be. Now, I know I can find out. Well, was there a time that the Supreme Court of the United States actually did hear jury trials? Now, I could be wrong. Okay, I'm just reading the Constitution. You would think the Supreme Court of the judicial branch of the United States of America would understand due process. Now, I told the Supreme Court, I'm going to fire every fucking one of you!